So, like Marika said, I am a social worker. I graduated from the university here back in 2004. Worked at St. Patrick Hospital for 10 years and then made an easy transition into hospice because that's where my love is. My love stems from growing up with my grandparents, two of the greatest loves of my life, and they still are. One's here with me and one is here in my heart. And every day when I get to see people, it's just a tribute to them and my way to continue my bond with them. So I appreciate being able to do this work. I'm glad you guys are here because I think one of the most important things we can do to honor the people who have gone on ahead of us and thinking of us being as people who are going to go ahead eventually is have this conversation, make it not a taboo subject, because the way we celebrate children coming into this world, it would be nice if we could celebrate us moving on to the next, whatever it is. And part of some of those questions is, what does it look like when we go? What does it look like for us? What does it look like for the people standing around us as they're watching this happen? And then what about the things we leave behind? Whether those are things we want to will to people, whether they be physical things. We also talk a lot about leaving, what's the word I'm looking for? When we leave, not emotional wills, no. Another topic, what's the word?
Legacy?
Legacy will. I'll think about it later. Not an intellectual will. It's another thing we work on in social work, and we write down what we would want people to learn from our lives, and it's a way of paying our own history forward. It'll come to another day. But for now, Steve gets center stage here to talk about, what are those documents that we do need to have in place. And I'm going to push it one step further and say it's not just about the documents, it's about having the conversation around the documents. Because the documents are great, but when I'm at the hospital and somebody shows up with a document, and this son knows about it, and this one doesn't, and somebody just died, and it's an awkward situation. It's awful. And I would just ask to not leave family in that situation. So it's not just about the documents. It's about having the documents done well and then having a conversation around the documents. And if you can't have the conversation with those people, designating someone who can have the conversation. Maybe it is your lawyer who can understand it and carry it out the way. Steve can talk more about that, but it's a good gift to give your family to have these things organized. So.
Well, thank you very much. Am I standing?
You're standing, you're sitting, you're wherever you're comfortable. If you guys can't hear, though, let us know so that we're sure.
Sure. I'm Steve Darty, and I'm owner of the Darty Law Office in this town. It's an estate planning firm. It's what I love to do. I specialize in it, I guess, if you want to call it specializing. It's what I pretty much limit my practice to do. So I spend all of my time, 90% of my time, having these kind of conversations. Hopefully that will bode well for tonight, and we can cover these topics. The theme of tonight was passing on the golden egg, I saw. And I like to think of what I do as trying to pass on a little bit of the golden goose as well, because it's when I think of estate planning, I see it different. I think that there are some antiquated beliefs in estate planning. I don't think that it's just merely death planning. As Marika said, I like to think of it as it's about the living, whether that is our living or our children or our grandchildren's living or people that we can benefit through charities or through the church or whomever. And that's kind of my focus. I don't think that an estate plan is something that you do once like a transaction and you put on a shelf and let it gather dust. I think that a good estate plan evolves as life changes, as children are born, as people pass on, as our asset levels increase or decrease, so should our estate plan. It should evolve. And so tonight, I understand that this is, a lot of this conversation will be driven by you, and I'll try my best to answer your questions. Oftentimes, a lot of your questions are very private questions, and it may not really be the best forum to present them in front of others, because these are all very personal. For that reason, I will be around afterwards if you have any more specific questions, because I don't want anybody to feel uncomfortable. But at the same time, I'd be very glad to address these things in general terms that the best I can. I guess the one caveat that I have, when it comes to incapacity questions, Mindy may be a better person to ask when it comes to more incapacity planning and long-term care and hospice care. I do build a lot of the documents, and so I see these documents as tools. We were talking about documents. It's not just the documents. I mean, a tool can be used to do a many number of things. It could be used inappropriately as well. So when I think of estate planning, the last thing I think of is the tool. When I visit with my clients, I'm trying to drill down to find out what is it that's specific with you or with you. And there's always different things. And so when I try to design it, I try to go from the inside out. And when a client comes in, I don't know what we're going to do. So I don't have a set number of forms that we're going to fill out and then try to build out. I will share with you the very basic estate planning documents that you have to have in order to not have any gaps in your plan. But it just really depends. I'll touch a little bit about trusts and when is the right time to use trust, and maybe juxtapose that to wills. But to begin with, the 5 basic documents when you think of an estate plan, and these are the very basic, isn't the number one is your will, and obviously that tells people where we want our stuff to go, and to whom, and in what amounts or proportions. The second document is a living will, and that is obviously the do not resuscitate. And as I share with people, it's when we get to the point where a lot of the documents refer to it is when the physician says that you have reached an irreversible point. Like Mindy said, hopefully there's a better place for us to go, and we want that to happen naturally and with dignity. And so that's the purpose of the living will. Now, a lot of terms can be used interchangeably, the next couple of documents. I'll refer to them as how I learned them in law school, but advanced health care directives, advanced directives, health care power of attorney, a lot of these are interchangeable, and sometimes it's all one document and sometimes it's different documents. In my practice, the third document would be a durable power of attorney. There's different types of powers of attorneys. You've probably heard of limited power of attorney, general power of attorney, but a durable power of attorney, it continues when we lose our capacity. There's a premise in the law that I cannot give you more than what I own. I can't give you my neighbor's car. Just like that, I can't give you my capacity to sign a legal document if I myself have lost that. So with a general power of attorney, which you may use with your family or business members or to sign documents, if you lose capacity, if you suffer a car wreck or you start suffering dementia or whatever the case might be, a general power of attorney ceases to exist ceases to be valid once you have lost that capacity. But a durable power of attorney continues beyond your incapacity, and that's the whole point of incapacity planning, right? So that would be your third document. And the fourth document I call my healthcare power of attorney. Back to the durable power of attorney, that just allows other people, typically one spouse for another, or if you're a single adult, oftentimes that is maybe your nearest child or your best friend. And that the durable power of attorney allows us to sign financial and legal documents for the other person. And it could be just something as simple as you're out of town and you forgot to sign your tax return, or it could be something more serious, such as we have lost the capacity to contract and this person can now file our taxes on our behalf or enter into some contracts. Again, the fourth one is the healthcare power of attorney. And the healthcare power of attorney allows us to designate someone to make healthcare decisions on our behalf. So if I've had a car wreck and I'm in the hospital, my healthcare power of attorney can tell the doctor, yes, if it's going to save his life, take his arm. Without me doing that, the doctors, they're sued way too often by lawyers, obviously. So it's gotten to the point in our society where the doctors are really, I mean, they're going to get sued by someone if they don't have someone from the family, if they don't have someone to take liability. And so that has driven a lot of our laws. But the healthcare power of attorney allows you to have an agent make that decision in the case that I present, and it's always not so sensationalized as a car wreck. It could be just if my brother, for instance, suffers dementia and he has appointed me as his healthcare power of attorney, I can say yes or no to certain medications or treatments or such as that. And the last document that I'll touch on is the HIPAA authorization, HIPAA, and it stands for the Health Insurance Portability and Accountability Act. And doctors and healthcare administrators are not going to speak to our loved ones about our medical records because it's against the law, basically. And the only people we have statutory rights to access their medical records are our minor children. So a lot of my clients, when their children turn 18, they come in and they sign a healthcare power of attorney. So if the kid has a wreck or suffers an illness, they can continue to make parenting decisions for their health. But there is no statutory right for you to have access to your spouse's medical records. So I like to get all of those done and put into at one time. And it's very good to talk to your doctor or your local healthcare providers about, if the 5 wishes and things like that. But it's also with my documents, they're good from Anchorage to Miami because you may not be here when you need those documents, okay? So it's good to have those as well. Those are the 5 basic documents to an estate plan. Now, if you'll notice, only the first one dealt with dying. And the last 4 dealt with incapacity. And statistically, regardless of our age, we all stand a greater risk of becoming incapacitated in the next 12 months than we do of dying. And oftentimes the reason is because before we die we become incapacitated. So those last 4 documents are every bit as important as the first one. Now, as an estate planner, I see this, you have 3 ways that a person can die in terms of what it is that I do. And the first one is dying without a will or a trust, without any plan in place. And it continues to surprise me how many people still have nothing in place. And if you die without anything in place, that's called dying intestate. And if you do so, the state of Montana has a set of laws called our intestacy statutes that says if you pass away, it's pretty much a formula for how your assets are distributed to whom and in what amounts. And it's not, they do the best we can, but because all of our families are not the same, we may not want our next of kin inheriting all these things for a number of reasons. Maybe our next of kin is very wealthy. And maybe our next of kin is not someone that can be trusted or responsible with certain assets. So the laws do the best they can, but they're obviously very generic. It also, not having anything in place lends itself to all kinds of fights and all kinds of problems. The next way that you can die is with a will. And a will does not go into effect, is valid, but it does not go into effect until you die. So it doesn't address any incapacity issues. And then the third way that you can die is with a living trust. And a living trust, much like a will, says this is where I want my stuff to go, into whom and into what amounts. But the thing about a living trust is it becomes effective immediately. So we can go in there and start addressing incapacity issues such as, well, we'll talk about living probate. So those are the 3 different routes. So when I have a client, we're either going to do a will-based estate plan or a trust-based estate plan. And most people are kind of surprised when we think of a trust or living trust. We think of the very wealthy and trying to avoid estate taxes. Well, it's not true. You know, a complex estate is not complex because of the dollar value. I can have a client with $10 million, but if they're going to leave it all to one person, that's as simple as it comes. But when we have issues like blended families, my definition of a blended family is when two people marry and there's at least one child from a previous relationship, that's a complex estate plan, especially if you die and you don't have anything in place. So real quickly, I'll touch on probate, and I'm just going to kind of, I don't have a set, I'm just going to start, I don't really have a set presentation. I'm just going to share with you the things that I address in my job and kind of allow you to kind of drive me as well. But probate is basically, for many of us, you know, we have not gone through, or I have. I have lost both of my parents, and so I have gone through that process as a client as well. So I understand it from the legal side, but I also understand it from the other side. And I think that perspective has benefited me in terms of dealing with my clients and hopefully having a little bedside manner in addition to just drafting documents. But that perspective is something that you really can't gain until you've gone through it yourself. But probate is the state of Montana's way, or depending on what state you're in, to make sure that, for lack of a better phrase, we close the books on all of your assets. Meaning, before any of your heirs are able to inherit your assets, we're going to pay off your debts and your taxes. So the policy is, if I loan my neighbor $5,000 and he passes away, I should have some kind of forum to get that $5,000 back before the heirs all inherit and I'm left out. So that's kind of the policy. So probate has a good policy and I'm going to sit down for a second. The typical process is, if I have a client come to me and we have to go through probate, is that I'm going to petition and open for probate at the county district court, just at the clerk of at the district at the county courthouse district the clerk of court. Sorry, excuse me. I keep wanting to say clerk and recorder's office because I spent about an hour there today, but it's not the clerk and recorder's office. It's the clerk of court. So we're able to do it informally, meaning I don't have to go stand before a judge. I can just file these papers. Then I'm going to publish an ad for 3 weeks. Usually in the Independent, because that's the cheapest, and that gives notice to the creditors to come forward. And then there's 4 months that the creditors have to come forward and file a claim saying this person owes me money. If they do not do that within 4 months, they are barred from recovering. They can't come later and state this person owes me money. So that is a good thing, is that we close the door on creditors or predators or people with frivolous claims. But probate, depending on how complex it is, it could be anywhere from a 6 to 18-month process, and if it's contested, it can go 2 years, and it can be quite expensive because it is a court overseen process. Meaning, I file the documents and I wait for the judge to get to them and to approve or disapprove and stamp them. And it's to protect the public, it's to protect creditors, it's also to make sure that the state and the federal government gets their taxes. But whenever we have a publicly administered process, the costs go up. So a will, if you die without a will, if you die intestate again, or if you die with a will, you must go through probate. Now, if you die with a trust, that is a privately administered process, and the way that works is, if I am hired to administer a trust, I still go through some of the same procedures to try to get the 4-month limit on creditors and everything, but the difference is everything is handled privately. You can Google Jackie Kennedy Onassis' last will and testament, and you'll see everything that she left, to whom and what amounts. And I think it's quite sad when you take this lady who was never given any privacy while she was alive, and now after she is gone, you know, people are digging around and looking at what went where. But why am I telling you that? Because I can. The point is it's public record when we go through probate. Unless there's something really evil that happened or nefarious and the judge seals the records, you can go down to the district court right now and say, I need to see the probate records, and they'll point you right over where to go. And so you can look and see, you know, It's not that you're going to go be nosy about what your neighbor did with his assets. My point is there are predators and there are bad people out there that prey on young people and old people who inherit money. So some people like to utilize trust not because they're a Kennedy, but because, which by the way, JFK had a trust, Jackie O did not. But a lot of people aren't using trust because they're extremely wealthy. It's because they want their privacy, and they also want things to be administered very effectively and efficiently. And so just to talk on the cost, a will costs less up front. A trust costs a little more because it obviously takes more time to create. But the administration is typically less expensive for the administering a trust because it's handled privately. It does not take as long as a will.
Excuse me, but a will doesn't necessarily state dollar amounts. It can say percentages or...
That's correct.
To accounts.
That's correct. The statement was that a will does not necessarily state exact amounts. It can be percentages of my assets.
Or just names of accounts.
That's right. Names.
Right?
That's correct.
So how much of a violation of privacy is that then?
Well, it depends. I mean, you're going to find out where one half of your stuff went to.
Who was named in the will?
Right. We can find out where it went. We may not know exactly how much went. And I'm not trying to beat up on wills. I'm just trying to compare the difference of a will and a trust.
What's the cost of doing a trust?
It really varies. I asked that question. I don't want to be deceptive. I'll give you a range, but it's kind of like taking a vacation. You know, how far are you going to go and how long are you going to be? It depends on it depends on what we're doing with the trust. But ranges are typically anywhere from $1,500 to $3,000 depending on how many moving parts.
To set it up or to administer it?
That's to set it up. And the ranges include all of those incapacity documents, because when someone comes sees me, I don't just do a trust. I'll do an estate plan, and so that's typically the range. You know, I would say $1,500 to $3,000 is a pretty good spectrum.
In the planning phase or after the death?
That would be to establish it. The administration, it just depends on what we're doing. For
I
instance,
thought this trust wasn't established till after death.
no, that would be a testamentary trust.
Or testamentary.
So you can create a will and create a testamentary trust that says, when I die, I want my personal representative to establish a trust. And to me, that's kind of like saying, I'm not going to rake my yard not today, I'll rake it tomorrow, and I hope it don't snow tonight. Because what happens is we lose the benefit of the trust, which means avoiding probate. So if we create a testamentary means it happens after we die. We can create a will that says, upon my death, create these trusts for these purposes. Well, the will's got to go through probate. And so different practitioners have, different philosophies. You may have one plumber that tells you one thing and another plumber that tells you another. But my views are, just because I've seen the good and the bad of both, I tend to prefer the trusts. And it's a personal preference, but to me, I'd rather have a little too much horsepower in something than not enough. So, real quick, what is a trust? How does it work? When I was in law school and took estate planning and trust, I would not have taken it unless it was a required course. I was thinking, oh my gosh, I'm going to spend the next 6 months, learning taxes and everything, and that's not what I wanted. But once I got through with it, I said, you know what, this is not that big of a deal. Once you because we don't know, what is estate planning? Where does family law stop and estate planning start? And what does estate planning stop? And what does tax law start? And it kind of varies. But I'll try to write on here. I don't know if this board's a little, if it's not doing well, I'll just wing it. But the way that it was taught to me many years ago is to think of a trust. Now, and I also want to verify, there's all kinds of trusts. I do everything from special needs trust to pet trust to even gun trust. But what we're talking about is a revocable living trust. Okay, so when I say trust, that's just going to be the scope of what we're talking about tonight. But the way it was explained to me a long time ago was, think of it as your treasure chest. And there's 3 parties to a revocable living trust. I know that's I wasn't brought here for my handwriting, that's for sure. But there's 3 parties to the trust. And the first party is the grantor. And the grantor is the person who puts stuff into the trust. That stuff might be your savings account, it may be your home, typically it is your home, or any large asset. I typically say if you got an asset that's worth more than $10,000, a bank account or what have you, we probably want to get that into the trust. And when you do that, the grantor creates a set of written instructions. It's called your living trust agreement. And this is the constitution for this. This says whatever's in this trust, whatever's inside here, must be used or not used for all of these explicit instructions. And the second party to a trust is the trustee. And the trustee is required to follow these written instructions. Well, while you are alive and you have your capacity, you're both, okay? So you're still in charge of all your stuff. If you put something in there, you can reach in there and take it and go to Vegas and blow it all. It's not an irrevocable trust where we put something in there and we no longer have access to it. And those are used for a number of reasons, but usually estate tax planning. So the thing about being revocable or revocable, I'll use both pronunciations in the same sentence sometimes, but it means that if you set up a revocable living trust and the next day you change your mind, you say, I just woke up, I don't feel good, I want everything to go back into my name personally, you can tear it up and put things back into your name. So you have lost nothing. You've lost no rights, no privileges, no tax advantages whatsoever. And then the last party is the beneficiary, and just as the name implies, they're the person who gets the stuff when it comes out. So why do people go through all of this trouble? And the answer, beyond just avoiding probate and that, is asset protection. And it doesn't matter the amount of the asset so much as how you want it to come out. And there's a number of different ways that we can do this. But let me use a couple of stories of what people are doing. I had a client, and her total assets was basically her house, and it's about $150,000 thereabout. So not an extremely wealthy person by any stretch of the imagination, but it was, is all hers, so it's 100% of her stuff, so it's very important. And I want to treat that the same as my very high-end client is, everything that you have, we're going to give it the best possible plan, and I'm not going to prescribe you more medication than you need. But so I drilled down and I said, I kept trying to find out what is important to you. And finally, after about 45 minutes, I realized what was important to her. She was a widow. She had 3 children. Those 3 kids all lived in, 3 adult children, they all lived in different states. Her concern was that after she's gone, they're going to lose touch. And it happens. We all see that. And this was the big thing in her estate planning. We all have our own big things. For me, it was about a 5-cent skillet. And it was the same skillet my dad used every time we went hunting and camping and fishing or whatever. I can see the campfire, I can see the skillet, and I can hear and smell the bacon in it. It wasn't worth 5 cents, but it was important to me. So each family is a different thing. But her thing was, didn't want to lose touch. So what did we do? This is how we used a trust for the $150,000. When she is gone, and she's alive and well and doing great, and her kids don't know this, but this is what we did. When she passes away, we're going to sell that house. And anything above $100,000 is going to be divided amongst the 3 kids. But we're going to take that $100,000 and I'm going to put it in trust. And that money can only be spent on one thing, and that's an annual family vacation or reunion. So even if that money does not make any interest, if it doesn't grow at all, that's at least $5,000 per year for the next 20 years that I can get a place at Flathead Lake for the 3 kids to come. And guess what? Each year the kids get a gift from Mom. Because when we leave things to people, guess what? It becomes theirs, right? When we get things from people, it becomes ours. And oftentimes it gets converted into things that we regret we converted so quickly. So, in this case, here's $100,000. That would have been $33,000 that would go to each of the 3 kids. And I don't know how long that would be around. Maybe as soon as they got to the next car lot. I don't know. But I know this. Even after that first year, there's still going to be $95,000. And hopefully that's going to grow and compound. And so we don't know long. They may be going to Hawaii after a while. But the point is that's how we can use a trust to do more than just death planning. So when I talk about, let's talk about planning for the living, is look what we did with $100,000, right? And also the same thing I use for family cabins, is that we may have a family cabin. We want to keep it in the family. And I have a lot of clients who, you know, are from the Highline or whatever, and they have, you know, farms and ranches in other places, and it's important that we keep that in the family and it doesn't get broken up through your children's divorces and other kind of nightmares. So we use trust. We can do simple things like this guys, their family cabin probably has a total value of $50,000, but it's their place to go every time that the family gets together. So there's a tradition we want to keep. That's their heritage, you know. It's been in the family for 2 generations, and now it's going to stay in there indefinitely. And so we're going to set aside, just a token amount like $20,000 of life insurance. They have, you know, a couple $100,000 lives. We're going to put $20,000. It's just there to grow to pay the taxes, and kind of, you know, if we need to throw some gravel on the road or whatever, we got it. But I put in there a bloodline clause. It can only go to descendants, you know, and I don't want to get off on too many tangents. I got another client that when he grew up, he was very impoverished, and so his big thing was with his children was big Christmases. Because there were certain Christmases he didn't get anything. And so what did we do? We're putting about, and I can't recall the number, but it was in the neighborhood, it was less than $100,000. And it can only be spent on Christmas presents for his grandkids and the descendants of his family. And so, again, we're talking, it's amazing what you can do with $20,000, $30,000, $40,000, $50,000. And you know, if we have a house that's paid off, or a retirement account, you know, it doesn't take long to have a lot of assets. I got another client who has 4 children. All children are doing really well. They're doing as well as mom and dad did. And so if any of those children predecease my client, their share goes to the Missoula Community Foundation. So they're going to adopt the Missoula Community Foundation and leave that shares portion of the money to them. And that's kind of getting off topic here, but the Missoula Community Foundation is whatever you want to do. If you want to put a bench on the river with your name on it for, you know, $1,000, they'll do it for you. They're the infrastructure for that. But you could also, you know, adopt your church or whatever the issue might be, whatever is special to you. If you've got you know, if it's the art museum or whatever. And so I tell my clients, let's try to, I hate the phrase think outside the box, because if we use it now, we're no longer thinking outside the box. It's too used. But the point is let's just think. Yeah, let's think outside the. So the point is that I try to find out what's important to you, and then we start talking about that. It has nothing to do with your money. It's like we'll do the best we can, as long as we can, with the money. Yes?
In your first example, where they were going to have $5,000 over 20 years, who actually does the administering of that? I mean, like, do you get my question?
Sure. So after you're gone, we're going to have like successor trustees, 1, 2, and 3. Okay, so while you're alive, you're the trustee, right? And then after you're gone, it might be your oldest child, your closest child. It might be your CPA. It might be your attorney. It might be a trust department at the bank. This particular lady, her middle child is a CPA. We identified that middle child, and we know that he's going to follow it, and he'll really appreciate what mom did. And so when you appoint a family member to administer it, that's free. But sometimes we don't want one sibling writing checks to the other siblings. This was a situation where he was a CPA, so it just made complete sense. But I have some clients who've asked me to do it. That's not typical. I'm more of a planner, but you can hire. any attorney. You can hire an attorney in town, or their First Interstate Bank, Wells Fargo, and U.S. Bank here in town. They all have trust departments. So there's plenty of options. I know one guy, he appointed a financial advisor, and that's not uncommon. So it's really up to you to think in your particular family dynamics who would be the right person. You know, it's kind of, I had this conversation with my young parents who have no assets, but they have a lot of life insurance because they get, 3 and 5-year-old kids. And, what I tell them is whether you're alive or not is your responsibility to financially care for that child at least until they're 18. But what we don't want to do, we don't want the legal guardian inheriting through the children. So I create a trust, and we'll have a legal guardian over here that raises the children, and I have a trustee over here writing checks. That way, if they need a new vehicle, they need a minivan for the kids, we can get them a minivan, but we're not going to get them a Range Rover, right? So that's one dynamic of depending on the family. And my whole point is meant to say is you may have your younger sister may have the heart of a saint, but if your older sister is a CPA, well, we're going to let the older sister handle the financial care if the younger sister can't balance her checkbook, right? So I usually, after finding out what's going on in the family, I'll say, what about this person? It just starts to sound like the right kind of person. But let me talk about something real quick, and then I'm going to be done with kind of why people use trusts. Is when we leave things to people with a will, or you can use a trust and leave things to people outright. It doesn't have to be held over a period of years. Examples. A lot of people who have trusts, they'll say, all right, I'll use a nice round figure. If there's $1 million in there, let's say that they have a house, retirement account, and some life insurance, and they have $1 million that they leave behind, and they have 3 kids. They might say, well, first of all, that $1 million is generating interest each year, right? And income to kick out. So your beneficiaries will be getting that income each year. But we don't have to give them the principal, okay? So let's say that there's $1 million in here, and you have 2 kids. I'm going to use your imagination here a little bit with me. We could leave them, at the time of your death, we could leave it to them outright. Or we could say, let's just give them the interest. Let's say that it's earning 5% interest. And so that's $50,000 a year. We could give the 2 kids, especially if they're young, say less than 40. I consider that young in terms of, of today's ages, that let's give them let them get the $25,000 each per year. Again, just to kind of, so you can follow me with the math. If it's $50,000, and I'm just using this to illustrate a point. How does this work? What's the functionality of it? The 2 kids would get the $25,000 each every year in interest without touching the principal. And then maybe at ages 40, 45, and 50, we start carving out thirds of the principal. But a lot of times we'll say until the kid reaches 50, right? Because that'll give them 20 years to learn what it's like to manage passive income. That way they don't blow it all at once, right? Or we may tie it to certain other things. We want to make sure that the grandkids get through college or whatever the goals might be for that particular family. But I have, I just did one the other day for a client. He has 2 daughters, loves them both equally. One daughter saved every penny she's ever made. The other one spent every penny she's ever made. So what did we do? I finally figured out, the big thing was him is he was worried about daughter number 2 would not have a retirement account. She's too generous. What she has, she shares, right? And that's awesome. It's good to be generous, but it's good to have a retirement account too. So what we did is for the older daughter, the one that's has saved every penny, when he passes away, or the survivor, him or his wife passes away, that daughter's going to get her $300,000 or whatever it is at that time. But with the other daughter, she's going to get the interest on that $300,000 until she's 65. And then at 65, she gets her retirement account. So we gave her a retirement account because we know she's not going to have one otherwise. That's called parenting from the grave, by the way. But here's the big thing that scares a lot of people. If we leave the $1 million to our kids outright, what are the divorce statistics this day? It's about 50%, right? Unfortunately. Let's say child A and child B. They each get $500,000. Again, just using nice round numbers. 3 years later, child A goes through a divorce. What is it going to look like? It might look more like this, right? Very quickly it might look like that. And guess what? This right here might represent the house you left behind. Child B might be making all the right decisions, never even seen the inside of a casino, right? Just doing everything right. But then one icy day hits a jogger and it's their fault and there's lots of medical bills. This $500,000 could very quickly look like that. So life happens. Divorce is a 50% rate, unfortunately, this day and age. And small business ventures fail. People file bankruptcy all the time. So I see this all too often where it turns out to that. So what we're trying to do is protect the A and B from life. So Mindy, if you left here right now and you go out and you're the one that hits the jogger and you call me and say, Steve, I need you to put all my assets into a trust to protect them, I'm going to say, I'm sorry, I'm not going to be able to help you, because when you hit that jogger, they were your assets. If we hide them, that's called fraud. So I can't, but what I can do is I can protect your children, because what happens is when we leave money to them and they're getting this $50,000, $25,000 or whatever it is each year, the $1 million of principal stays intact, right? So when this person goes through a divorce or this person hits the jogger, how much do the plaintiffs get? They don't get anything. Why? Because the trust owns the assets. The assets were not in their name when they hit the jogger. So all they can try to go after is this distribution, like garnishing wages. The trust does not get married. The trust does not divorce or drive a car or enter business decisions. That's why people use trust, that in the privacy, obviously, and the ease of administration. And real quick, while we're talking about the problems that I see, I want to give you a problem that I have seen more than once, and I was sharing this in front of a group of people, and my assistant pretty much broke down in tears, said this happened to me and my sister. Our tradition in Montana is we own our homes with our spouse as joint tenants with right of survivorship, right? Well, that's great. It also works very well when the first person passes away. But basically, when we own our home as joint tenants with right of survivorship, what that means is we got the husband here and the wife here. When the first person passes away, always knock off the men because I'm a guy. This is what happens. It goes to the wife and she owns it 100%, right? Well, if we have had a good marriage, it's not uncommon that usually about 5 years later or wherever the appropriate time is, that this person misses that relationship and they remarry. And people are remarrying today in their 90s. You know, you see it, which is a wonderful thing. So what happens is a lot of times you'll have two seniors, or it could be young people as well. But the older we get, the more assets are involved, and that's when the problems are compounded. This is what I see. So wife, widow, now owns the house outright. And later on we get married. She remarries. She finds the gentleman who has the same amount of assets that she has. He has a house, he has a savings and everything, so what do? No reason to have two houses. Let's combine our assets. So he sells his house and he takes his assets, his cash, and they put it in the bank jointly, right? And so what does she do to show her, the only thing equitable to do is put him on the house with her as a joint tenant with right of survivorship. She has access to half of his cash, he has access to half of her house. Makes sense. There's nothing nefarious or evil about that. But then this is what happens. When she dies, husband number two gets the house and all of the money. There's nothing evil about this. This is just surviving spouse gets the house. And so what happens is, remember husband one and husband two, or excuse me, husband one and wife, their kids, A and B, they just got disinherited. That is a real life scenario I see all the time. Okay, so we want to protect ourselves from this. We want to protect our children or our heirs from creditors, predators, and bad spending decisions themselves. So that's kind of what I wanted to share with you, the bad things I see happening in terms of the sad things that just there was no ill intent. It's just this is the way things have played out, and the kids get inherited or disinherited. This situation where we can leave stuff to our children, give them 10 years to practice inheriting a little bit money each year, let them make mistakes, blow the money, and realize next year I'm not going to do that. And then if they have got 10 years experience, then they may be responsible enough, maybe the first time they've ever managed any money beyond their paycheck, right? So let's give them some experience, allow them to make those mistakes that people make between 20 and 40, and learn from that. And then as they get a little older, they're financially mature enough to handle the money. Plus, the other thing is once we start getting near 50, we start making a lot less of the same mistakes, don't we? Mm-hmm. Sometimes, and it depends on the difference of it. Sometimes, life may have to kick me in the head 2 or 3 more times than it does you before I learn the lesson. But typically, when we start getting near 50, we've gone through the divorce, we've lost the business, we've gone through the second divorce. We finally learned that what, Mom and Dad were right when they said that you're supposed to save 10% or whatever. And so that's the whole idea. It's not just about trying to, this is your life savings, but it's also, we don't want to leave a bunch of money to our children and deny them the whole ability of learning the importance of working toward a goal and reaching it, of denying them the sense of self-satisfaction of working hard and reaping the rewards for it. Sometimes it's the saddest thing to see is when people get too much and they're never allowed to become who they could have been. And it doesn't have to be a lot of money. It's just enough to throw them off their game plan. And it's the reason that lottery winners are all filing bankruptcy in 5 years is you get skewed, you get used to a certain lifestyle, and then as the money runs out, you see it all the time, it's replaced with debt. And that's not a sustainable model. So I've probably gone on a little bit long, but I've wanted to talk about the good, bad, and the ugly. And so I'll start answering some questions, and hopefully I won't have to draw as much. You were first, ladies first.
Say you leave interest to child A, and child A dies before they get the, is that provided for in the trust what happens, or does that go according to the child's testamentary plan, or what?
It goes to your plan. Typically, that child's assets will go to their descendants, and if they have no descendants, it'll go to the other beneficiaries. And and it just depends on. That's what I typically see. But we can do it however you want. Some people are pretty serious about, I want it to go to the other kids for whatever reason, maybe because they just don't know the grandkids that well. But in any event, what we're trying to do is prevent it from going oftentimes to the spouse or the potential outlaw, as they call them.
Right. So if there's only one child and that child?
If it's just one child and they have no descendants, first of all, I'm going to have backups. We're going to talk about it, and I'm going to have my client leave their money to a charitable organization in Missoula before I have them leave it to Uncle Sam. That's the one relative we want to disinherit, right? And just real quick on estate taxes, everybody wants to worry about death taxes. I don't want to pay any death taxes. Well, let me give you the good and the bad. When we think of death taxes, there are 2 types of death taxes. There is inheritance tax, which is like income tax for the people who inherit. And then there's estate tax, the money that the tax we have to pay for having the audacity to die, right? Well, the only tax that we have to worry in Montana is the federal estate tax. We repealed all the state taxes, so There's no inheritance tax. There's no state of Montana estate tax. So all we have to worry about is the federal estate tax. Well, guess how much that limit is? Anyone know? I'm sure someone. How much?
600,000.
Another guess? It wasn't that long ago. It was $600,000, and every year it seems like it has changed. If we died in 2011, we paid none. And I forgot which one of the gazillionaires had the financial planning wherewithal to die in 2011 and paid none. But the way that it is, if we live in Montana and we die, you pay no estate taxes unless you have assets north of $5 million. The actual is adjusted for inflation, and currently that's $5.34 million. And for a couple, you double it. So that's each per person, and that's 1/3 of 1% of the population. So don't feel poor that you don't have that you're not facing estate taxes. Yeah. So when we're doing estate planning, the last thing we're probably doing is thinking of, we're not going to let the tail wag the dog. We're not going to worry about the estate taxes, right?
Well, I was mistaken to not be concerned about the estate taxes until then I learned about income taxes in respect to a decedent, so that all qualified money that is held by the person who died then has to be taxed before it becomes part of the estate. So say you have a 401k or an IRA, all those funds, because they were pre-tax dollars and the interest gets taxed.
Let me touch on that real quick. Yeah, when it comes to retirement accounts, remember, those are deferred tax savings. So when that money comes out, the taxes are taken out. But don't confuse that with estate taxes. So there's different ways that we do it. We can roll that over into the surviving spouse, and if it's a big issue, we can even stretch it out for the children's life. But this is what I'm starting to do with a lot of my clients. It depends on how many other assets there are besides the retirement account. If there's plenty of money to take care of the heirs, one thing that I'm suggesting to my clients is, listen, if you've got a bunch of deferred taxes when it comes out, maybe you want to contemplate leaving your retirement account to a charity. Charities are tax deductible, okay? So that's one. So a lot of my clients will think, well, instead of giving half of it to Uncle Sam, I'll give 100% to the Grizz or whomever is your chosen charity. Some people it's their church or what have you. But that is one way to get around it. Is, well, if I've got enough other assets, I'll take that IRA, the 401k, and I'll use that. I'll just donate it outright.
The greatest percentage of the estate after that.
Well, it just depends. I mean, it really depends. If it's the greatest percentage of the estate, we're going to do. I'm going to set up an IRA trust, and what I'm going to do with that IRA trust is I'm going to stretch that over the next 50 years, taking out only the minimum required distributions. It just depends. I mean, I don't do a one-size-fits-all, but you're exactly right. It's a huge issue, and a lot of people don't even think about it. So you're way ahead of the game to even understand it. But did I explore that enough? Okay. Yes, sir.
What is the fee of a trustee?
What is for a trustee to administer? They're all different. The banks, if you go with the trust department of a bank, and I don't want to speak on behalf of the banks because they may have different approaches, but typically, sometimes I see them charging a flat fee like $2,000 a year, or some of them, it depends on the size of the estate. If it's a small estate, they might say a percentage of the total assets. So sometimes we want that because if it keeps, sometimes it's best to have a neutral, regulated party overseeing that. But oftentimes, if there's a good, trusted child that's going to do it for free, it's free. For me, I mean, my rates are, it depends, but usually around $200 an hour. And so probably, 5 to 10 hours a year, tops, maybe much less than that, because a lot of it, if it's just writing a check for the income each year, that might take me, it may take me 15 minutes. This is the other thing I wanted to say about trust. When we put that money in here, the $1 million away, and we lock it away, and we say for the next 10 years after I die, all they're going to get is the interest and the income. That's not really true, because what we do is we give the trustee, whoever that successor trustee is, we give them discretion for 4 things. It's called HEMS, H-E-M-S. Health, education, maintenance, and support. And maintenance and support are kind of vague, squishy terms, and we want them to be, and that's for what we don't understand. So, for example, we've got the $1 million in here, and we're kicking out the $25,000 each year for the next 10 years to the kids. Well, if something that comes up, an emergency for health, education, maintenance, and support comes up, the trustee has discretion to reach into that principal and spend as much as they deem advisable. For instance, the kids need $10,000 in dental work. Perfect example. All right, the trustee will reach into the principal, and that would serve as an advance for that particular child. Or education. You know, the example is, well, instead of going to our great university across town, they get into Stanford. Well, that's great, but now we've got a problem. You know, unless they go there on scholarship, we may have an issue. If for something like that, then we can reach, because the whole idea is we want that money to work just like if we were alive and they came to us and said, hey, I got in Stanford, or I get to study abroad for 1 summer. I mean, we want to support that. And if we were alive and we had the money, we would do everything we would do to support them. Or the roof caves in. There's your maintenance and support. The child is legitimately unemployed for 6 months. That's another maintenance and support. So there's certain things but the trustee has discretion. Okay, so they can't say, I'm stressed out. I need to go to Hawaii for a week. Well, that's not going to cut it. You know, plastic surgery may not be a health expense. I don't know. It's going to be up to the trustee. But there are ways to get in there. So we're not just putting a lock on that forever.
Yes, sir.
Say you're setting up a revocable living trust. What's involved to like put your house into it, or your car, or stocks and bonds?
It's always much simpler than most people think, because really all we're doing, when you put things into a trust, that's called funding the trust. And really all you're doing is you retitle your assets. So we're not creating some entity like a corporation that's going to require an accountant and opening up these specific accounts, depending on the particular bank. Most banks, for instance, let's say that you have a savings account at First Interstate Bank. What they're most likely going to do is they're going to give you a form that says, an authorization form to change the name of the account. So we're not even going to take that money out and put it into a new account. Now, I did have American Federal just today with one of my clients said, hey, we want to open a new account. That's their internal policy. So we're going to let them do it, but they're doing it. It's their work. But typically what will happen is you're going to sign an authorization form at the bank, and they're going to change the name on your account to, instead of Jim's account, Jim's Living Trust account. And for your house, it's so simple, and I do 3 or 4 of these a week. I just do a quick claim deed from your name to the name of the trust, and I file it at the clerk and recorder's office, and we've just put your house into the trust. And you know, it's $14 to record it. So it's pretty simple. And one thing that I do also, in addition to those 5 basic documents, is I do what's called a personal property memorandum. And so the trust, think of that as trying to handle all your big stuff, but now we've got all the keepsake stuff, right? You know, and we may not want that to go to our heirs. You may want to go to your best friend, you know, if it's your fishing buddy, or if you may want to leave some art to the school or the museum or something like that. I do a personal property memorandum, and it's basically about 4 pages of lines. At the top it's got your name, at the bottom it's got my law firm's name. It looks nice and legal, but what you're doing is, this is where we go in there and we write Grandma's ring to Cindy, and you initial it, and you do this on your own time.
Is that the same as a tangible distribution of property?
It would be. At the time of your death, it would be a distribution of the tangible property, and we would make reference to that in the trust. And this is how we get about giving out those keepsakes to the individuals that we specifically want. And here's the thing, is you don't get the Christmas card next year. You just go in and scratch through it, and you put someone else's name and you initial it, and that's I think law is best when it's addressed simply. You know, oftentimes wisdom and simplicity go hand in hand. And that's a perfect example of a great way, a wise way to handle your stuff, you know. And so far as, but because the fights happen over dad's gun, mom's ring, grandma's accordion. Those are where the fights are. And the four-wheelers, for God knows why, the four-wheelers seem to be an issue. But this is where you can go in there and you can handwrite things, and it can be, and the trust or the will reference this and says, I leave everything other than what's on that personal property memorandum, and you evolve it, you change it, you add things, you scratch through things as you sell it. Now, cars are very simple. With cars, we just go down to the Department of Motor Vehicles, we bring a death certificate, and we just change title just like if you were selling it to me. I mean, as long as you have the documents, they could care less. It's very simple. But I go ahead and I assign my cars to the trust. But otherwise, if you come into me, I'm not going to change the title on your cars. I'm just going to address that when you die. Why? Because we're Americans. We go through cars every 3 to 5 years. Maybe not all of them, but a lot of us do. And so I don't bother putting the cars in, unless it was like an antique or collector's item, something like that.
So if your house and property are already paid for, is it like a grandmother's ring?
No, we still want to get the house, because a lot of times that's your largest asset. We're going to put that into the name of the trust. The personal property, grandma's ring, etc., it's the keepsakes and heirlooms, my skillet, those are the things we're going to put on the personal property memorandum.
Can you put your property in the trust if it still has a mortgage on it?
Sure. And it happens so often, it doesn't trigger the due on sale clause. There's the Garn-St. Germain Act that says, you, Mr. Lender, if they transfer their house, a residence, into a revocable living trust, you cannot trigger the due on sale clause. It happens all the time.
Due on death.
A due on sale clause, think about it like this way. So if you own your home and you move out of your home, whether you downsize or upsize or cross-size, and you keep your home and you want to keep it as a rental property, and there's still a mortgage on it, and you say, all right, Steve, I want to do this. I'm going to say, well, let's put it in an LLC. That way, if the renter falls and gets hurt, they can't come after you personally. All they can come after is what's on the inside of the property line boundaries, right? So we're going to put that into an LLC. Well, if we do that, if we transfer it from your name into a corporate entity, or you just give it to your sister or whatever, when it changes, typically the lender's going to say due on sale, because we did not approve your sister. We don't know anything about the LLC. If you transfer this, and it dates back to, some of you may remember in like the 70s, there was a lot of people that would buy a house and they'd turn around and sell it to someone else. And they would do what's called a wraparound mortgage. Well, the bank started getting stiffed by it, and they said, well, what we're going to do, we want to prevent you buying a house, and then, so the object would be, I buy a house for $100,000, and I turn around and I sell it to someone who can't get lending for $110,000 the next week. I just made $10,000. If they default, it comes back in my name, I sell it again. But what was happening is, anyway, the point being is, there was 2 mortgages. Maybe you could sell it. Maybe you take out a mortgage for 6% and you turn around and you sold it to someone else for 12%. So you're just making 6% coverage. And so the bank said, no, can't do that anymore. If you sell your home or you transfer it into an LLC, the mortgage is due. You pay us off. When you transfer your residence into a revocable living trust, there's no due on sale clause triggered. So the mortgage, it happens so often now that oftentimes the bank prefers that. They know it's better protected. Yes.
I have a question about preservation of assets.
Yes.
A concern about children marrying and, divorcing and losing money or whatever. Is it true that money that an adult child has prior to marriage, if kept in a separate account and not commingled with marital funds, is preserved against it?
Statutorily, yes. I often say it depends on the lawyers involved, because most divorces end up in a settlement. Okay? So we might say, yes, you keep that $100,000 you inherited, but I'm taking the house. So it is used as leverage. And it's a very, we could talk for an hour about that. And then there's also, we have the laws where the longer you're married, the more of the properties we get. And, if you're in there for 15 years, I think it is, you can get 50%. So we have all those laws, and those are nice and neat. But this is what happens. You're going to settle. It's a negotiation, you're going to settle.
Another question is, I know that spouses, well, in this case, the wife is responsible for her husband's medical bills. So in the case of devastating illness, the wife could end up losing most of the assets because all the money went to the husband's illness and survival.
It is, and it becomes a very complicated analysis, especially when Medicaid becomes involved. Yep.
But I was looking into this regarding my mother who's 94 in New York, and she's not married, so there is no spouse to have to pay her bills. But I came across something curious, and it said, but in other states, children are responsible for their parents' medical bills. Go to this site and look at what your state laws are. And I went to Montana, and it said that children are responsible for their parents' medical bills.
Let me clarify that. It's a Filial Responsibility Act. Filial Responsibility Act says we are responsible for our parents if they become indigent. Now, there's a difference of getting your parents off the street and putting them into a nursing home, okay? Taking care of our parents, our filial responsibility might mean bringing them into our home. It does not mean that we have to place them into an assisted living facility. However, on the East Coast, what's going on right now is there are some lawyers who are successful at taking these filial responsibility laws and expanding that into, yes, you did have a responsibility to put your parent into a nursing home, and that's where all the case law is going right now. And it hasn't in New York. So
New York doesn't have that.
well, let me rephrase it. The East Coast. I apologize. It's heading west, but right now we have yet to have any case law in Montana where, and I can say this because I hired someone to research it. We haven't had any case law in Montana yet where a child has actually been sued under the Filial Responsibility Act to being required to put their parent into a nursing home, and therefore, once you establish that precedent, then you can kind of come back. There has not been, not using the filial responsibility. There is, again, the Filial Responsibility Act is just like our children with our parents. We have a responsibility to keep them healthy, or at least, off the streets. Yes, sir.
Two questions. One is how important is it to have a declaration of homestead exemption? And then the other one, I missed way back when you started, I missed your fifth item.
Fifth item is a HIPAA authorization. It's a Health Insurance Portability and Accountability Act. And it is an authorization. You'll name someone, whether that is your spouse or your children or all, that you're going ahead today and you're telling, you're stating, if something happens to me, you, medical administrator, you doctor, you can talk to these people about my medical, you can release my medical records to them. And your question, the first part of the question was the
Homestead exemption.
Yeah, homestead exemption. That idea is that if we are sued and we lose everything that we have in a lawsuit, we have an exemption, and I believe it. I'm going off the top of my head. I think it's $250,000. Maybe it depends on different things. I think there's 100 for something and 250. And you forgive me, it's not my area of expertise. But if we are sued, we can keep that certain equity if we stay in the home. And I think it's important to have. It does not protect you from a foreclosing on your house, because if you have a mortgage, it is tied to the house. So it's more about unsecured debts that they come after, correct? And typically when you if you buy your house through a real estate agent, when they're making you sign all those documents, whether you know it or not, you're probably signing one of those, and they file those with the deed when that. But certainly something to think about.
If you own your property, does it have any implication?
If you own your property, does what have any implication?
Does the Homestead Act, does it If somebody sued you and you own it,
Yeah, it's only going to apply to the property that you do own, the house or the real estate,
they can't-
and it's got to be your residence. Okay, it's got to be it's only going to apply to your residence. It won't apply to your lake house.
so they can't, right, but they can't take your own home away from you.
No, but I mean they can't get to that equity inside there, correct? Unless it's the mortgage company themselves. So what will happen is typically when someone is going through this, by the time they get to a bankruptcy stage or they get to, they've probably already mortgaged that property to the hilt to try to avoid that. And so oftentimes it never gets to that.
If you don't have a mortgage, if you own your property, do you
Okay.
have protection?
You do up to your amount. I think it's $250,000, correct?
Thank you.
So if you have a $500,000 house paid off, they could still file a lien against half of your equity. I mean, they could file against it anyway. Yes.
Isn't the homestead exemption, isn't that when one spouse has to go into the nursing home and there's not really enough funds to pay for it, and you're getting Medicare, Medicaid, and so the nursing home, the stay is paid by Medicaid. As long as the other spouse is in the house, they can't take the house.
That's right.
But if the spouse living in the house dies, then the house goes to the nursing home to pay for all past bills and future bills of the remaining spouse.
It would no longer be a residence at that point, yes.
Right.
Right. And Medicaid asset, you hear of MAPTs, Medicaid Asset Protection Trust. It's a very complicated part of the law because if it's not done correctly, you've just committed fraud. But the idea with Medicaid Asset Protection Trust is I'm going to take my house and I'm going to put it into a trust. That way, and I'm going to grant this. And it's going to be an irrevocable trust. Basically, I'm giving it away. So I no longer have it. It'll go to the beneficiaries would be my children or whomever. And that way you live in the house and they come after you and say, hey, I'm just a renter. I don't live here. But the problem is you do have to pay fair market rent, and you also, there's a 5-year look back, which everyone's kind of familiar with it. So that's to keep lawyers from sitting at the front step of a nursing home putting people's houses into trust as they go in. So they think 5 years is the difference of good faith and bad faith, I guess.
You gotta get on before dark.
Thank you for coming. Thank you for your questions.
I have a question about what she said. If you have a 401k plan or pension plan or profit sharing plan, retirement plan, when you pass away, the heirs have to pay the tax as they receive that money.
It is typically withheld. So just like your paycheck, you're only going to get 70% of it that's going to come out, and that's typically how it's handled. It just depends. It just depends. That's the caveat on who the custodian is. But when you pass away, the typical rules is that's got to be paid out in 5 years. But if there's good planning ahead, we may stretch that out for the life of the youngest child, or when the first spouse dies, oftentimes it's rolled over into the surviving spouses.
When I signed up for mine, they asked me to write down who my beneficiaries were.
Right.
And I didn't realize that there was going to be a tax that was going to have to be paid on it. And I thought it was an inheritance for them.
Right. If it's like a Roth IRA where you've put in post-tax, and there's not. But if it's a deferred tax, remember the whole point is we use these retirement funds to allow them to grow tax-free or tax-deferred as long as possible. And there's great savings to it. But at some point, I mean, it's just a paycheck that you haven't got yet. At some point when that paycheck comes out, you will have to pay the tax on it. But it's not an estate tax. Don't want to confuse that. Yes, sir.
Large family, several siblings. One parent's deceased. 2 members in the family, children, are co-executives of an estate, and one has power of attorney. And what safeguards are there if the person that has the power of attorney is not executing that position in a responsible manner, what safeguards are there in place?
There's a number, and we see this all too often, unfortunately. When someone dies and someone is appointed personal representative, you'll hear the term executor, you'll hear PR for personal representative, they are appointed by the court to be in charge of all the accounting, making sure that the funeral gets paid, all the debts are paid, and that the heirs get what they're supposed to have, and it's a court overseeing. Whenever there is a question, and this usually happens when there are out-of-state siblings, and they're not there to see what's going on, and maybe it's a second wife, maybe it's a stepmom or a stepdad who is now the PR, and they never were that close with the kids, and the kids are now out of state. All you have to do is request the PR post a bond, and if it's requested, they are required to post a bond. And then it doesn't matter. I mean, I guess the keepsakes really don't have a dollar value on them, but in terms of the accounts, if you file a if anyone requests the court to require the PR to post a bond, basically insurance for the total amount of the estate, which is bonded, they have to. And so, but sometimes that can be expensive, but that's if it's really ugly. I have a suit right now. I don't litigate. I bring on litigators. I just do the estate. But I was retained. I was retained by 6 children of a gentleman who passed away 2 years ago. They all live out of state. He passed away intestate, without a will. And he had been through 2 marriages and had always said, "If I die, I'll never remarry again." That's what that was kept saying. "I'll never remarry again." And he kept telling his children, "If I die, I just want to get that straight."
I like how he said, "If I die."
Yeah, right. I had to back up because dying is almost as sure as taxes, right? But that was his whole point, was I'll never marry again. Twice was enough for me. He passed away, and then 2 days later, his friend, she went and opened probate and was appointed the personal representative because she was his common law wife. So now we're having to litigate whether or not she's the common law wife. And so in that case, the first thing that we did is we required her to post a bond because she wasn't the wife. I mean, she may have seen herself as that. She was a friend. She was a dear friend, but a wife probably not. And so the children are thinking, first of all, we don't want her involved. We want this to be a family affair. And second reason is, what are her motivations for doing this? And so we simply requested that she post a bond. And so if she blows any of the money, then the bond company will reimburse the heirs.
What if the kid is an executor and that kid suddenly dies, and then who becomes the next executor?
Well, we'll have to get another one appointed, and it'll be much the same process as the first if it's not nominated in the will. Usually, oftentimes, it's the closest child for logistical reasons, but it may not make sense. It could be the children might just agree, let's hire this accounting firm to handle it so we're not at each other's throat.
Or it could just be specified in the will.
Yes.
Thanks.
I don't know if we'd finish yours.
Just along that same lines, 9 siblings, 1 parent's deceased, 1 is still living, but incapacitated, dementia, whatnot, needs 24-hour care. And 1 person has the power of attorney, and there's 2 of them. The power of attorney also is one of the co-executors on the estate, both for the living parent and one's deceased. But there's no other people named as far as, should this individual pass on or something happen, becomes incapacitated to carry out the wishes of the parents.
You would just if the personal representative themselves becomes incapacitated, then the heirs would petition the court and request a new PR be appointed. And you can do that. They don't have to become incapacitated. If it's someone that you just don't trust, or you think, you know what, they're in over their head, you can request that they be removed, and as long as you nominate someone else to replace them. And The courts don't like to get involved if there's a good reason and they can agree with it. They'll typically do that. They don't like to pick and choose between the family members. But so if it's a case where you have a personal representative that you think may not be, whether they're just not financially capable of handling something that difficult, maybe they just don't have a good attention to detail, maybe they've got a history of blowing money, whatever the case is, you can request they be removed, or if you just request they post a bond, that's automatic. And oftentimes what the court wants to do is they want to get the closest child anyway, and the closest child might be a nutcase. So it's the child that lives the furthest away might be the logical person, because the personal representative doesn't have to open the bank account in the county where the decedent passed away. If the child lives in Miami, for instance, someone dies here, the personal representative can open the bank account wherever they are. So it doesn't always have to be, and it's not always the best case for the.
So who do you go to ask for a bond to be posted to?
You follow. Best thing to do if it's something like that, just hire an attorney. Say, listen, I need you to petition in the probate court. In our probate case, just make a petition that the bond be posted in the best interest of the estate. You make the language as neutral as possible, unless you just really want to explain why and lay into them. But if you just make it neutral, say in the best interest of preserving my parents' assets, is our opinion that or our request that a bond be posted. Boom, it's automatic. It's statutorily. Yes, ma'am.
What about oil and mineral rights, say on farms or ranches in eastern Montana? Now, do those need to be mentioned directly in the will, or would that be considered part of Grandma's diamonds? Or,
Right.
That would be just something that, like a codicil to your will?
Yes and no. Yes, meaning that if, say that you don't mention them, then we are going to be able to pull those in through probate, just like if you died without a will. However, the best thing obviously is to mention them, but the very best thing to do is if you have a will, go ahead and title them into the name of the trust. And I just did that today with a guy who had some mineral interest in North Dakota. We went ahead and we did a quick claim deed on those mineral interests, transferring those mineral interests into the trust, because his whole point was the whole family fought over those when his grandfather left him to him, and I'm not going to use his language, but he made it very clear that his family was not going to get him when he's gone. And so he left it to a charity, actually.
Use the geocode or however it's printed on.
Yeah, it's a simple process. If is not complicated at all. We file a quit claim deed or a mineral deed, and yes.
In the case of mineral rights, if there are active oil wells, how does the estate value those, as a cash flow or as a future value?
It's a good point, because her question is, how do we value something that, and we're that, we have a, and even as far over in Missoula, I'm getting a lot of oil and gas work because it's spilling over. Everybody's so backed up. But you may have a piece of ground that's worth $800 if you were to value it for its agricultural purposes, but it may be kicking out $2,000 a month in royalties. So we have two different. You have the leases, which the oil and gas companies they lease from you the right of those mineral rights, and then they'll also sign agreements for the royalties. So if they actually are drilling and actively drilling and pulling money out, they're going to pay you a percentage of what comes out. So it can be a couple of different things. But when it's that way, if I have someone that's got a lease, we're going to probably do an addendum to the lease, name the trust. But we want to get all of that reflected, definitely, because those are the hard things to track down. And while we're on that, you know what the best thing you can do as an estate plan is to write a letter. Just write a letter. And letters can be for different purposes. For my young parents, I tell them, for your 3-year-old daughter, you write a letter to them for their high school graduation, in case you're not here, in case you die tomorrow and they never get to know you. And I tell this into my dad's also, and I have a 6-year-old son, so this kind of is dear to me. Is I was telling all of my moms and dads, listen, how much do you know about your grandparents? A lot of them, they knew them very well. A lot of them, they died before they were born. And I'm saying, put out, what are your values? What are your traditions? What are your heritage? What is it that you want? What do you stand for? what do you want your kids to know that if you don't ever get the chance to teach them, instill this in them, what is it you want them to know? And so the cobbler's children has no shoes, or holy ones at that. So finally I got around and I did it myself. But what it did for me is that all of a sudden it got me on point, and I started becoming a better father. I started talking to my little guy about maybe the most important thing is to have good attitude. We started talking about empty and half full glasses, and we started talking about go be the friend, don't wait for someone. And so I'm kind of getting off on a tangent, but writing letters can be many things. It could be expressing what it is that we believed in, what we were taught, and leave this. And now it goes on for generations. But also what your letters can do is say, hey, I've got a storage facility out near the airport, and I've only got one. And then, so I tell people, write a treasure map, leave a treasure map. Write a set of instructions, so if something were to happen to you.
What about audio tapes? I've seen people use that.
I'm sorry?
Audio tapes.
Audio tapes would be even better. Videotapes would even be better.
Explaining
right.
why you did what you
I think that's beautiful, because I've also seen cases where people, they left their poorer, for lack of a better word, financially poorer child more than they did their physician child. And I've seen that wealthier child confuse that with not being loved as much. And so I say, explain. I mean, I had a grown guy, multimillionaire, just crying. And, when you're going through that, you're not making rational decisions anyway sometimes, and you're hurt, and hurt gets confused. Explain why. If you're not leaving everything out equally, explain why, And it can oftentimes be a compliment to the person who got the lesser share. So
That is the best segue for next month's talk about storytelling. I mean, really, you just naturally talked about, we talked about those material things that you can hold and you can pass on. And then there's that other part of your life, of your legacy and what you pass on. And that's what really next month's talk is about, is storytelling, and that your grandkids are 3 and 6 years old. How are they going to remember what you're trying to tell them now? And when you talk about passing on those most important things, are they really your assets?
No.
Or are they your assets in how they actually use them and turn them into what your family culture has been, or your family legacy and what they can turn those into? And so I hope you can join us next month too, and think about how out of the box.
Yeah.
But
Manifesto.
not in the box.
Manifesto, the word you're trying to think of?
Kind of, not quite. But your will manifesto. I know, I'm going to wake up in the middle of the night and have to gather you all here again.
Oh, don't you dare.
I'm gonna really throw
Memoir.
this whole thing, is because I don't live in Missoula any longer, but I did, and I grew up in that world of maybe there's going to be a nuclear war, and we're putting it all in missile silos, and I know many people in Missoula, and in my age range, we were so freaked out about raising kids. If there was going to be a nuclear war, I know a lot of us that chose not to have families. And yet at the same time, we now are in a situation of taking care of our parents. And because we don't have children, and we don't have to think about writing a will, should we?
Sure. And back to what Mindy was talking about, you can leave a written legacy. But the last thing I wanted to touch on, because I think it's so important, is in your letters, it's really hard for heirs, and you've probably had to do it yourself, when you're going through your mom or dad's house and you're wondering, at what point do I stop looking? I've gone through the drawers, I've gone through the filing cabinets. What is it I don't know? As an attorney, I start calling I send letters to all the banks, I call all the storage facilities, and we still don't know at what point do I stop looking. Were there any life insurance? What point? So leave a letter. Leave a letter of instructions that says, I do have a storage facility and I've only got one.
But you also need to leave all your passwords for
Yes.
if everything's on computers.
Yes.
You haven't even mentioned that.
I tell people, I said, list all of your passwords in the accounts that they go to. Absolutely. See, when I do an estate plan, I put it in a big 3-ring binder. Everything's in one book. And I tell them, you tell your kids if something happens to you, get the book. And that's all you got to do. Get the book and call Steve. And that's all. The treasure hunt is over. The scavenger hunt is over. You know, and in there you might say, in my top right drawer, I have a keychain, and on that keychain is a copy of every key that goes to a lock. If there's not a key on there, there's not a mystery lock somewhere. And so, as I was saying, that for $5, one of the best estate planning devices you can buy is a key ring that has, or those sets of keys with a little circular white label on there that you can write Lake House or whatever it is. And if you come across a lock and there's a key, and there's no key in the mystery key envelope, you know to hire you call the locksmith. You quit looking in the attic for a key, you know. So leave a detailed list of a scavenger hunt, just that way. And if you do,
call a locksmith and they can do it, but if it's online and you don't have passwords, it costs thousands of dollars to break into accounts.
Absolutely.
So all of you, if you have anything computer, have that documented and give it to somebody that's not in your house. It should be somewhere separate.
Right. Absolutely, it's an excellent point. We're in this digital age, and this is what I tell people: if you'll just keep a record of all your accounts over a 2-month cycle, you'll get all the important accounts.
So it'd be nice if everyone could afford an attorney and could do this right. If they can't, is the things you find online, or like organize your life by filling all these things out. Is that at least a better start than doing nothing?
The worst thing is nothing.
I think of young parents like me who don't have, access to an attorney or even a family planning center.
Right.
Is it better for them to at least get something in writing?
Absolutely.
Absolutely. The thought of legal Zoom to me is probably like a knockoff of that makes you cringe. But is that at least better than doing nothing? It's better than nothing.
The problem is if you can afford an attorney and you use legal Zoom, because I have a colleague here in town that just took a $99 will, and by the time that they straightened it out, it was $14,000 in legal fees. But if you don't have anything, just get something. That letter that you write, the passwords that you include, is so important. Is what we want to do is we don't want anyone to have to make any decisions when we're gone. We want to make those decisions today, and then incorporate that with, these are my values. This is what I stood for.
Thank you, Steve.
How does the law recognize, my daughter-in-law is from Japan, and she's a Japanese citizen still, daughter, dual citizenship. So what happens by law to the money she inherits from her family?
That is a whole nother subject. And if she's a dual citizen, then we're going to be okay. But oftentimes, a lot of my clients, their spouse is Canadian. And so we do what's called a QDOT, a qualified domestic, non-domestic trust. But I'd be glad to address that a little more in detail. I think we're about out of time. But it's not that simple. But there's ways that we can address it.
Does she have to pay taxes, federal taxes, on the money she's inheriting?
If she is in Montana, she owes no inheritance tax unless there's some. She's in Utah. I don't know if Utah has a state inheritance tax. If they do, she might. But that's a really interesting scenario. If it's coming from overseas, what do you do with it? I have no idea. I've never had a client inherit money from overseas.
We're the overseas account.
That's right.
That's a different feeling.
That's
the overseas account.
Yeah, exactly.
Usually we're shipping it out instead of, right? Thank you, Steve, for being here tonight.
Thank you for the good questions. Some great questions.